Good morning everyone and welcome to the webinar for Enforcement Agency Services DPS 953. In this webinar we will be talking about legislation and regulations. Just to introduce ourselves, I'm Sarah Jarvis, the category buyer for corporate and financial services here at YPO. And I'm joined this morning by Dave Chapman, Client Service Director from Marstons Limited, part of the Marstons Holdings Group. Before I go through the agenda, I'm just going to go through some housekeeping. You've all joined this webinar in a listening mode only. However, you do have access to type questions throughout the webinar. These questions will be answered after the webinar and shared with everybody that has attended. So today we're going to cover the background of the DPS, explain what an enforcement agent does and what they have to comply with, breathing space schemes, vulnerable people, complaints procedure, body camera regulations and taking control of goods. So firstly, I will just quickly mention who YPO is. YPO was established 45 years ago and we have a wide range of customers within the public sector. We're 100% publicly owned by 13 local authorities, which means all our profit goes back into our public sector customers. We have a large choice of available leading UK suppliers, so we can provide you with everything you could possibly need to successfully run your organisation. So just a little brief overview of the DPS before I pass over to Dave. So the Enforcement Agency Services DPS 953 includes the collection of all debt types which a contracting authority may have a requirement to collect, plus other services an enforcement agent can provide. Examples of debt types include council tax, parking fines, non-domestic / business rates, road traffic fines, sundry debt, housing benefit overpayment, social care debts and university accommodation fees. Examples of other services debt collection include advice / consultancy, evictions. Please note these are only examples of additional services. Authorities must have the appropriate authority and orders to allow enforcement agents to carry out the service. Examples include liability orders, writ of control or repossession orders. All suppliers have registered enforcement officers and/or High Court enforcement officers and comply with Taking Control of Goods Regulations 2013, Taking Control of Good Fees Regulations 2014 and the Certificate of Enforcement Agents Regulations 2014. So what is the DPS? So DPS stands for Dynamic Purchasing System. This is an electronic system established to purchase goods, works or services. The DPS will remain open for the life of the contract and new suppliers can join at any time subject to them meeting the selection criteria and mandatory requirement. Awarded suppliers can then participate in the customer's further competitions. Currently, we have 15 suppliers awarded onto the DPS and these are all registered on the YPO website under the Enforcement Agency Services section. So what will YPO do? So YPO will support and offer guidance contracting authorities with their further competition, which includes provide templates for further competition documents, sample questions and specifications, suggested timescales, terms and conditions. Once you've wrote your further competition, YPO will then check it, go back to you and provide guidance and advice. YPO can then facilitate your further competition through our procurement portal. So that means we'll manage all clarifications, we'll download submissions, and then we'll provide successful and unsuccessful letters. We'll check your letters before it's awarded against your evaluation score. So that's just a brief overview of what YPO does. For more information, please get in contact with me. My contact details are right at the end of this presentation on the last slide. So now I'm going to pass over to Dave, who's going to discuss legislation and regulations in more detail.
Okay, so what an enforcement agency does and what they have to comply with. Lots of things, lots of technical things like obviously loading your cases, which involves electronic interfaces between the local authority and the enforcement agency, and that includes interfacing cases back to you and also payments. Data cleansing, residency checking, electronic tracing takes place before we even begin to start the work. We can propensity grade cases and append data such as telephone numbers. And new addresses, all in compliance with data protection and also GDPR. Once we're satisfied that the data is as good as it can be, we will issue the notice of enforcement. This all takes place in less than 24 hours. We issue the notice of enforcement, which is a statutory document, and it requires 7 clear days before we can make an enforcement visit. The document also signposts national debt advice, provides the debt balance, what costs have been added at this stage and what the potential is for future costs. It also contains contact details and ways to pay, preferably plain English compliant to make it easy for customers. Just trying to move, oh, here we go. So once we've issued the notice of enforcement, we're entering what's called the compliance stage, and this provides engagement opportunities for customers. And what we really want to do at this stage is get contact, make payment arrangements, collect payment in full, give customers advice, handle issues. We issue further notices, we issue reminders, and we do that through white mail, through email, through texting. That's all providing we've got the customer's mobile phone number or their email address, which we might have found during the cleansing stage, or the local authority might have provided us with the file. Preferably, if you can provide us with email addresses and mobile phone numbers, it gives us more opportunity to contact people while costs are at the lowest. So during this compliance stage, which typically lasts around 14 days, we're dealing with inbound and outbound telephony and voicemail. We still continue with electronic tracing where we get notices returned to us, gone away. We make payment arrangements, we monitor the payment arrangements, we're gathering information about the customer, and we're also signposting customers who we recognise might be having financial difficulties or may be vulnerable. We're also involved in resolving disputes, because quite often they'll be disputing the debt, and then we will liaise with our local authority partners to try and help with that resolution. The cost for this stage is a fixed £75 fee, regardless of the debt amount, and it goes from a parking debt, which can be about £80, or it could be a high court rate, for a jumbo jet, which we've had in the past for £20 million. So regardless of debt size, it's a £75 fee. So once the compliance stage has ended and we've given the customer enough opportunity to contact us and pay at the £75 stage, we move to the visit stage to take control of goods. The legislation says the first visit cannot be, well, we've got to give them 7 clear days notice from the notice of enforcement. What does clear days mean? Well, in the legislation, it says it excludes days on which events occur. So we can't include the date of issue as one of the 7 days and the date of delivery. So we need to factor in postage. If we're sending documents first class, we've got to factor in, we've got to add 2 days to the 7. If it's second class, we've got to add 4 days. We can't count Sundays, bank holidays, Good Friday and Christmas Day in calculating the 7-day period. So when you factor all that in, and the fact that you might send it on a Friday and there might be 2 weekends involved, 2 Sundays, there might be a bank holiday coming up, it might be Easter, it's safer to have a standard parameter, more like 12 to 14 days before you make your first visit. Unless, of course, you've hand delivered it, because if you've hand delivered your notice of enforcement, you know exactly the day that they've received it, and you don't have to factor in the postage. And we might do hand delivery of a notice of enforcement if it was a particularly contentious debt, like a big business rate debt, and the customer, the local authority, was worried that that business might abscond. So once we enter the enforcement stage, it represents the second action under the enforcement power on the liability order. And again, it's a prescribed fee. It's £235 plus 7.5% for debts above £1,500. So if the debt was £1,600, it would be £235 for the first 1,500, and the next £100 would attract 7.5%, so £7.50. The visit fee would be £242.50. So when can an enforcement agent visit? Regulation 21 says the enforcement agent may enter, re-enter or remain on any day between 6 AM and 9 PM or during business common trading hours. So if it was a nightclub, we can make a visit outside of 6 AM to 9 PM. And when it says any day, that means Sundays, Christmas Day, Boxing Day, bank holidays, any day. Although we wouldn't do that without the permission of the local authority that we were working with. There's no restrictions on the number of visits in a day, so we can go 4, 5, 6 times the same day if we have information that leads us to believe the customer will be there that day. Regulation 22 provides the court to authorise the enforcement agent to enter, re-enter or remain on premises during times other than those permitted if and only if an application for authorisation is made to the court by the enforcement agent. This is quite unusual and not many enforcement agents have done this in the 5 years that the regulations have been operating. But it is a process that if we go back to court, we can make a court application to enter a property outside of the hours, the permitted hours, or to actually remain on the premises beyond the permitted hours. But it's a court process and it's a £205 fee. So how do we enter? By what means can we access premises? The regulations provide any door or any usual means by which entry is gained to the premises. So it could be through a loading bay to premises where a trade or business is carried on, or where the premises are a vehicle, vessel, aircraft, hovercraft, tent, or other movable structure. Essentially, it's the usual means of access. So it could be patio doors, it could be through a garage. If it's the way that a customer would normally enter a property, then it's permissible. We can't climb through windows anymore, climb over fences, climb over walls, get our ladders out, which we used to do prior to the new regulations. So entry is prescribed in those A or B methods. What can be taken into control? Paragraph 9 of the regulations says that an enforcement agent may take control of goods only if they are on premises that he has power to enter or on a highway. A highway is not defined in the Taking Control of Goods Act and regulations. So what is a highway? I think we all know what a highway is, but there are some instances where is a car park a highway? Is a rough track a highway? I think the definition really of a highway is anywhere where it provides usual access, public unrestricted access. So a car park can be classed as a highway if it's open to the public and it's unrestricted. Paragraph 10 provides that we can only take into control goods of the debtor. So they have to be goods that are in the debtor's name, including jointly owned goods. Paragraph 11 says that we can take control of goods anywhere in England and Wales, but may not take control of exempt goods. Therefore, the enforcement agent is not trespassing while undertaking duties conferred by the enforcement power. Yeah, I think just going back, we can only take control of goods where the customer lives or carries on a trade or a business. So what provides us with difficulties is if the customer has got a lockup, if the customer has got goods at another premises, a second home which he doesn't live in, a home that he owns and rents out. We can't attend to remove his boat if he's got a boat on a marina, because we can only, whilst we can go anywhere in England and Wales, we can only take control of goods on premises that we've got powers to enter. And the premises that we've got powers to enter are where they usually live or carry on a trade or business. So if they don't usually live in the boat on the marina and they're not carrying on a trade or business from there, we can't remove those goods. So that's just to give you some context of where we can go. And how do we take control of goods? We've got to do one of the following. We've got to secure the goods on the premises where we find them, secure them on a highway where we find them, or within a reasonable distance. So what we can do if we're taking control of the vehicle, if we're clamping a vehicle on a highway and it's going to cause an obstruction, then we are entitled to move a reasonable distance so that it's no longer causing an issue on a road. Another way to take control of goods is to remove them and secure them elsewhere, or enter into a controlled goods agreement. The most common thing that we do is actually enter into a controlled goods agreement, because enforcement agents don't actually want to remove goods. They don't want to take them to auction. We don't want to sell them. What we want is to use the goods as leverage to get that customer to pay. We would do that by entering into a controlled goods agreement. The controlled goods agreement is a statutory prescribed document. Paragraph 3 of the regs says that it constitutes a written signed agreement between the enforcement agent and the debtor or the debtor's authorised person, under which the debtor is permitted to retain custody of the goods, acknowledges that the EA is taking control of them, and agrees not to remove them or dispose of the controlled items or permit anyone else to before the debt is paid. So basically, we take control of the goods, we list them, we make a payment arrangement, and we tell the customer, look, as long as you're making payments as agreed in this arrangement, you keep the goods. If you don't pay as we've agreed, then we're obviously going to write to you, and there's a process for us to go through, but your goods are now at risk. Multiple referrals is an issue. Lots of local authorities, for whatever reason, issue multiple liability orders for a customer. So we've got a customer who might have 2, 3, 4 liability orders covering a number of years. When we receive multiple referrals for the same customer, each liability order referred creates an individual enforcement power. The enforcement agent may recover the compliance stage fee, the £75, in respect of each enforcement power to which the instructions relate. So the fee recoverable in respect of the enforcement stage may be recovered only once, regardless of the number of enforcement powers to which the instructions relate. Therefore, there's a clear legislative distinction existing between multiple compliance fees and a single enforcement fee. So putting that into plain English, if a local authority gives us 3 liability orders, we will charge £375. We'll combine them all together, and then if they don't pay at the compliance stage, at the £75 stage, then and we need to visit, we won't charge 3 £235 visit fees. Even though we charge 3 £75 compliance fees, we only charge 1 visit fee. However, the 7.5% is probably going to come into play, because when you add the 3 liability orders together, the total balance is probably more than £1,500. But the regs are quite clear. It is multiple £75 and it is a single enforcement fee. So to minimise the enforcement fee and any disbursement fees, if we go to auction, there's an expectation that if any cases reach the visit stage, the enforcement powers are grouped together and administered jointly. And what the regs say is that where those enforcement powers can reasonably be exercised at the same time. And what I'm saying in that bullet point is that we might be working for a local authority on 2 liability orders that they gave us in January, and then we're still working with that customer. We've got them in a payment arrangement, we might have got a signed controlled goods agreement, and then the local authority give us the new liability order in June. So suddenly, instead of having 2 liability orders, we've got 3. But because we've not received them at the same time, and two of them are in a control goods agreement, is it reasonable to action them all together? That's what the regulations provide. So we can separate them if they come at different times, but wherever it's reasonable and wherever it's possible, we would group them all together so that it minimises the fees. So what about when the customer pays? How do we allocate the money? The regulations provide that compliance fees are paid first and then enforcement fees are paid pro rata to the debt. So scenario one, if the customer pays at the compliance stage, then the compliance fee is paid 100% first and then the debt. So the debt might be £500, the enforcement, the compliance fee is £75, so the total is £575. If they pay £100, the £75 pays off the compliance fee for the enforcement agent, and the £25 then goes towards the debt. And then any future payments all clear off the debt. Scenario two, if the customer pays at the enforcement stage, when I say pay at the enforcement stage, I don't mean pay in full, he pays part amount. So the compliance fee is paid first, 100%, then the debt and enforcement fee are paid pro rata. So using the same example, it's £500 debt, £75 compliance fee, £235 enforcement fee. The debt balance is now £810. If they pay £100, £75 goes towards the compliance fee, and the other £25 is paid pro rata towards debt and enforcement fee. So which is the bigger, debt, the enforcement fee, or the actual debt? Well, in this case, the actual debt is bigger, so more money goes towards the debt than goes towards the enforcement fee. It's pro rata. What is pro rata? It's a process that ensures only auction fees and compliance fees are paid in full, and that the enforcement or sale fees and the debt are paid in proportion to each other. So no situation exists where there is only debt or fees left outstanding. So what it means is that once we've taken the compliance fee and the customer's paying a payment arrangement where we've made an enforcement visit, there'll never be a situation where the £235 is paid in full and there's debt outstanding. It will always be, any payment that's made, some goes to the enforcement fee, some goes to the debt. Another common situation is where customers pay direct to the local authority and not the enforcement agency, despite being told by paperwork and telephone calls and the enforcement agent themselves that they must pay the agency. Customers, sometimes they don't like the stigma of that and will pay directly to the council. What the legislation says about direct payments, well, it's legislatively silent. There's no specific reference either sanctioning or prohibiting the transfer of payments between the local authority and the enforcement agency. Challenges from customers commonly relate to the customer choosing to pay just the debt element. So in the example we've said £575, they just pay the £500 and they leave the £75 outstanding, and what they're actually implying is, well, we're not going to pay those costs. We're going to pay £500 direct to the council. The council have got the debt paid, and I'm not paying those costs. And what then happens is the regulations provide, as we've discussed, that the £75 actually is paid first. So when the council receives that £500, they should pay the enforcement agent £75 and keep £425 for themselves. So there's still a £75 balance outstanding on the council tax account if it's a council tax debt. When that happens, if the council transfers that £75 to the enforcement agent, which is compliant with the regulations, a customer will query the council's legal right to do that and say, well, why have you done that? I paid you £500. I didn't want to pay anything to the enforcement agency. Why have you given them £75 of my £500 payment? Well, the answer is no legislation permits payment transfers, but no statute prohibits it either. It's legislatively silent. So doesn't say you can, doesn't say you can't. But the regulations are clear in how that payment should be appropriated. So while an enforcement power exists, any payments made constitutes proceeds, and payment priority allocation rules apply. Compliance first, then debt and fees pro rata. Then the process ensures no instance occurs where only debt or only fees are left to pay. Whilst an enforcement power exists, despite customer claims, there's no distinction between debt and fees. There is only a balance outstanding. So the £75 in that case would be a balance outstanding. So summing up, this is the last slide on the regs as such. How does it work, enforcement? Well, we have a compliance stage where enforcement agencies use dialer technology, multi-seat call centres, achieving 50% of collections at that stage. So 50% of what your enforcement agent will collect for you will be collected at that 50% stage with at that compliance stage with just the £75 cost. Also at this stage, we're going to identify 60% of potentially vulnerable cases in, through contacts, through written contacts, texts, email, and phone calls. Enforcement agents use bespoke treatment paths, bespoke lettering, intelligent use of data to try and engage with the customer, focusing on customer accessibility, offering multiple payment channels, and making effective payment arrangements. Industry standards, well, certainly for my company, 80% of our payment arrangements are kept. So if we can't engage at the compliance stage, and as I've said, we do with 50% of customers that we collect from, so the other 50% we're engaging at the enforcement stage. This involves multi-visit strategies, lots of visits, different times, different days, EA rotation systems, different enforcement agents trying again with the same customer, with enhanced audit and investigation teams, vulnerability and safeguarding processes. Enforcement agents are sitting guilds or IRRB accredited through training and qualification, and they wear body-worn video and use other doorstep technologies. All this results in less than 1% of upheld complaints. You will always get a complaint about enforcement because we're asking customers to pay, customers who potentially don't want to pay, customers who don't feel they have to pay, or they're being charged too much. So when someone's either ringing them, writing to them, or knocking on the door and asking them to pay, you're always going to get a complaint. But what should define a good enforcement agent is how many of those complaints are being upheld. As I've said, less than 1%. And then we've got the sales stage, which is very rare. It occurs in less than 0.2% of cases. Sales stages are individually case managed. They do involve locksmiths, storage and removal costs. Those costs you can apply those costs to the customer, but you've got to make sure that you've got invoices to back that up. You must use independent auctioneers to get the best price. And as I've said, it occurs less than 0.2% of cases. So, moving on to breathing space, very topical. We have it in Scotland currently, the debt arrangement scheme. It's going to be introduced in England and Wales, probably in 2021. So what's the driver for this? Well, the third sector debt charity pressures on central government to support people in financial difficulty more. And this led to the Conservative Manifesto pledge in 2017, Theresa May saying that she will implement breathing space to help people in debt. The ambition is to encourage individuals with problem debts to access formal debt advice and allow time to identify a sustainable solution to their debt problems and take control of the finances. The scope is England and Wales only. Scotland has its own debt arrangement scheme. The delivery, it was a 27-question, 3-month consultation exercise, which closed in January 2019. The Treasury reported the outcomes in June 2019 with 2 key commitments. Commitment 1, the introduction of a statutory 60-day breathing space window, supported by legal protection from any further creditor action and costs, whilst the debtor accesses FCA regulated debt advice. That's Financial Conduct Authority, from providers like Citizens Advice. Stage 2, if the financial assessment confirms the debtor is able to repay their debts in full over a reasonable timetable, commonly within 7 years and exceptionally up to 10 years, then a statutory debt repayment plan, called the DRP, based on the standard financial statements used by Citizens Advice and the advice sector, will be provided to creditors via a central portal administered by the insolvency services. The two elements can work independently of one another, with individuals entering breathing space without ending up with a DRP, or having a DRP without breathing space previously. As I say, the draft regulations are anticipated late this year for an early 2021 start. So who's eligible for breathing space? Individuals, jointly liable couples, and sole traders who are below the VAT registration threshold, which is £85,000, who access the FCA regulated exempt debt advice process, are confirmed as being in problem debt. There's no financial threshold defined as to what problem debt is. They're considered to have a realistic chance of entering into a debt solution. So a CVA, a creditor voluntary arrangement, a DRO, a debt repayment order, or bankruptcy. So you've got to be in problem debt. You've got to have a realistic chance of entering a CVA, DRO, bankruptcy. So your debt situation has got to be pretty bad. And you've not got to have been in breathing space within the last 12 months. This is a concession to local authorities who pushed hard, saying, well, we can't let people have breathing space in periods less than 12 months because we're sending a council tax bill every year. But realistically, until we see the full regulations, we won't know. The devil will be in the detail, but potentially you can have breathing space every 12 months. You can also have automatic breathing space if you're in receipt of NHS mental health crisis care, according to approved mental health professionals, social workers, nurses, occupational therapists, etc., trained in mental health and mental capacity law and approved by local authorities, not GPs, funnily enough. And if those organisations submit evidence for breathing space on the debtor's behalf to the debt advisor, then it's an automatic qualification. So what debts are included? As many as possible, enabling the process to provide a common standard of protection. Financial services debt owed to organisations like banks, credit card companies, credit unions and other lenders would qualify. Household debts, utility debts, central government debt, HM Revenues and Customs, DWP, universal credit advances, local government debt, council tax, business rates, benefit overpayments, sundry debts, including universal credit, third-party deductions. Parking and traffic penalty charge notices will apply. Business debts of sole traders operating below the VAT threshold will apply. What debts are excluded? Housing debt, mortgage, rent arrears. You're not entitled to breathing space from those debts. Debts incurred from fraudulent behaviour, so housing benefit overpayments due to fraud are excluded. Court fines, but not parking fines. Parking fines are included, normal court fines not included. Child maintenance is exempt, student loans debt exempt, social fund loans exempt, and personal injury liabilities. Who administers breathing space? FCA regulated debt advice agencies such as the Citizens Advice. They have got to deliver a formal debt advice scheme during the 60-day pause. So when you enter into this 60-day breathing space as a customer with problem debt, the problem debt that you've identified, your creditors are notified and they can't do anything for 60 days. During that 60-day period, the debt advice agency, like the Citizens Advice, provide that customer with formal debt advice. So it's not just a case of pausing for 60 days, it's 60 days and then engaging with that customer to help them work out how they're going to get through this debt, and whether at the end of it they're going to get the statutory debt repayment plan, or they're going to enter into a bankruptcy or a DRO or a CVA. So partway through the process, the advice agency reviews the debtor's conduct 30 days into breathing space to confirm that the customer is complying, to confirm, yeah, I'm engaging with this customer, we're working it through with them, and we'll be notifying you at the end of the 60 days what's going to happen. If at 30 days period the customer has not engaged with the debt advice, Citizens Advice organisation, then breathing space could be pulled at 30 days and notified to all the creditors, look, the customer's not engaging with us, breathing space ends. Realistically, we won't know until it starts as to how successful it's going to be. So the Citizens Advice, let's say, who's monitoring the breathing space, monitors the register to ensure debtor compliance with the 12-month entry rule. So when a customer applies for breathing space at, for example, the Citizens Advice, it's up to the Citizens Advice to then contact the insolvency register to check, to make sure that that customer hasn't already had a breathing space within the last 12 months. They will also define the statutory repayment scheme. In other words, how much they think that customer can afford to pay over how long, which can be 7 years or as long as 10 years. They will assess the debtor's suitability and submit repayment proposals to the portal. Whilst it says repayment proposals, as a creditor, someone who's owed money, you've not really got much of a choice to contest those repayment proposals, even if it is over 7 years and you only paying over a year, because they've got another council tax bill coming next year. If it's decided that using standard financial statements that the customer can clear this debt, but they're going to need 7 years to do it, then that's really going to be what you've got to take. They'll decide whether to remove defaulters from the repayment scheme for failing to maintain ongoing liabilities or for non-compliance with the debt repayment plan terms. So whilst you're in this, once you've gone out of breathing space and into a debt repayment plan, you've still got to pay your other ongoing liabilities, which if you fail to do, could put at jeopardy your debt repayment plan. They've also got to distribute payments to creditors under the DRP, and they will have a shared responsibility with the insolvency service. So it's not really clear yet, because the government haven't consulted on the statutory debt repayment plan, which you are entitled to at the end of the 60-day breathing space, as to who's going to distribute the payments, because it won't be the customer paying you as the creditor over 7 years. It'll be the customer paying either the Citizens Advice or the insolvency service, who will then redistribute those payments back to you. The debt advice agency will also approve any debtor credit over a £500 threshold during breathing space. So in other words, whilst they're in breathing space, a customer can still apply for credit as long as it's below £500. And if they want to apply for credit above £500, they need permission from the Citizens Advice or whoever it is that's managing it. The insolvency service is the principal administrator of breathing space. They operate a central portal for breathing space, case load, that notifies creditors of debtors' entry to or exit from breathing space and the detail of proposed repayment plans. So the insolvency service is going to manage this. They're going to notify creditors that your debt's been included in this breathing space, so you can contact them. It rules whether proposed repayment schemes are fair and reasonable or not, manages the mechanism for creditors to object to repayment proposals, maintains a register of those persons in breathing space, which is not publicly searchable. So whilst they're managing this register, it's not something that anyone can just go online and check. If someone's in breathing space or someone's in a statutory debt repayment plan, it will only be used by creditors to access the details of the individuals that owe them money, but not information of the other creditors of those persons. So there will be a process for creditors where your debt is included in breathing space or a debt repayment plan, where presumably you'll have a password and reference. You can go on the Insolvency Service website and check that that person's on there, but we haven't had that detail yet. The Insolvency Service will distribute payments to creditors under a statutory debt repayment plan, and as I've said, that's a shared responsibility with the advice agency which introduced it. So who administers breathing space? The 60-day pause. There's no further interest or fees to be applied to the paused arrears once breathing space commences. It prevents creditors from contacting the debtor concerning all arrears that are subject to breathing space assessment. So once a customer's gone into breathing space, that's exactly it. We've got to leave them alone. We can't add any further fees or interest. And as a creditor, we can't contact them and chase them. We've got to leave them alone, not put them under any pressure, under any harassment for that 60-day period. Debtor-initiated contact may be responded to. So if during that 60-day period the customer contacts you and asks you a question about the debt, you can respond to that and you can provide them a balance, but you are not allowed to contact the customer about that debt during the breathing space period. You could contact them about another debt that's not included in it, but not that debt. It also prevents court action being initiated, so you can't you can't go down a reminder route or a liability order summons route during the breathing space. But if you've already issued your summons for your liability order and they go into breathing space, you can continue and get a liability order, but you can't do anything with it. You've got to pause that. It pauses post-court judgment remedies, excluding attachment of earnings. So if you've got a debt that's in an attachment of earnings and it's in breathing space, you can continue with the attachment of earnings. But you can't refer a debt to enforcement agencies, you can't start committal action, and you can't start bankruptcy. The only thing that you're allowed to do is continue with an attachment of earnings and also a deduction from benefits. Although the attachment of earnings continue during the breathing space pause, they cease if it goes into a debt repayment plan, and they are then superseded by the debt repayment plan terms. So essentially, during the 6-day period, you can carry on with deductions and attachments, but if at the end of that period they enter into a debt repayment plan, they've got to stop, because you're now captured by the debt repayment plan over maybe a 7-year period. And I've mentioned previously as well that it restricts the debtor to a maximum of £500 credit. So what about ongoing liabilities, which we've mentioned earlier? Breathing space is not a payment holiday for other debts. It's just the debts that you've got included in that breathing space. Individuals are expected to maintain ongoing and subsequent liabilities. Creditors can contact and proceed against individuals for any ongoing liabilities, applying all the remedies and appropriate costs associated with the debt stream. Creditors need to advise debt agencies when an ongoing liability is not maintained, so the agency can liaise with the debtor to comply or risk removal from the DRS. So if you as a local authority have got 1 year's council tax in breathing space and the DRP, then but they're not paying their ongoing current council tax, you can contact the Insolvency Service and say, look, all right, we know that this old liability order is in the statutory debt repayment plan, but they're not paying their ongoing council tax, and that will then mean that the risk removal from the DRP. Only the liability in arrears is submitted under breathing space. So what about the costs? Who's paying for this? Public funding for debt advice is costing 59 million in 2019-20. And that's estimated over 560,000 sessions. So 560,000 interviews with customers, with organisations like Citizens Advice, providing debt advice. That's currently the situation. So the financial burden for administering the full process of breathing space and debt repayment plans falls upon the creditors. So if at the end of breathing space and I think it probably will. Most customers will go into a statutory debt repayment plan of up to 7 years. Everything they pay into that plan, 10% of it is going to be retained by the intermediaries that are managing that debt repayment plan. So 8% for the debt agency, such as Citizens Advice, for their costs, 1% to the payment distributor, who's either going to be the Citizens Advice or the Insolvency Service, and 1% to the Insolvency Service for its administration and oversight responsibilities. So if you've got a debt that goes into breathing space, which then goes into the debt repayment plan over 7 years, you're only going to get 90% of your debt back. 10% of it will go, as the slide directs. So quite a shock for authorities, I would have thought, to lose 10% of the debt and also have to wait 7 years for full payment. So, I mean, that is breathing space, the statutory debt repayment plan in a nutshell. So moving on to dealing with vulnerability. Taking Control of Goods Regulations 2013 and 2014 provide 3 regulations that mention vulnerability. Regulation 10, the enforcement agent may not take control of goods of the debtor where the debtor is a vulnerable person and is the only person present in the relevant premises. So, enforcement agent goes to a premise, the debtor is vulnerable and they're the only person there, we cannot proceed, we've got to withdraw. However, there will be lots of circumstances where the vulnerable person is not the only person present. There might be a carer, there might be a partner, there might be a parent, there could be another responsible person. And then the regulations would permit you to continue. Whether you would or not is debatable. I would have thought every enforcement agent would withdraw at that stage. But the regulations provide you can continue if they are not the only person present. Reg 14, the enforcement agent may not enter into a control goods agreement with the debtor if it appears to the enforcement agent they do not understand the effect of and would therefore not be capable of entering into such an agreement. So we can't enter into a control goods agreement, a signed document that confirms a payment arrangement and control of goods, if we believe the customer doesn't understand or maybe isn't capable of entering into such an agreement. So that might be someone with mental health issues, maybe dementia, Alzheimer's, or someone whose first language is not English, or someone with communication issues, such as blindness, deafness, are unable to speak. So if there's any doubt as to whether the customer can understand what's happening, we are not to proceed. Reg 12, where the debtor is a vulnerable person, the fees due for the enforcement stage, the 235, are not recoverable unless the enforcement agent has, before proceeding to remove goods which have been taken into control, given the debtor an adequate opportunity to get assistance and advice. So where we come across a vulnerable person at the visit stage and we're charging the 235 fee, we're not allowed to charge that 235 fee if we haven't given that customer adequate opportunity to get assistance and advice. There is no definition of vulnerability in the regulations. So what is vulnerability? What I would say is what is potential vulnerability, because there are lots of circumstances and characteristics and factors where we might think people would be vulnerable, such as age, financial hardship, illness, mental health, pregnancy. All categories where lots of people can be considered vulnerable, but not everyone. Not everyone. We've got lots of examples of elderly people, who are not vulnerable, and pregnancy not vulnerable, financial hardship not vulnerable. We've got to examine each case on its individual basis. So how do we define it? There's no solely recognised definition. Nor is it appropriate to base on a predictive and potentially restrictive list. Some triggers that can cause a vulnerable situation are temporary in nature. It's more appropriate to adopt a holistic view where customers can be classified as potentially vulnerable individually. Energy UK definition of vulnerability, which is also adopted by Civia, says that a customer is vulnerable if for reasons of age, health, disability or severe financial insecurity, they are unable to safeguard their personal welfare or the personal welfare of other members of the family. So for whatever reason, they can't protect themselves or can't protect their family, they can be taken advantage of. That would be a definition of vulnerability. When we look at vulnerability, a vulnerable person might be at risk from their own actions or the actions of others. There are circumstances where people might be classed as vulnerable. So circumstances around them, affecting them, following a stressful life event, a bereavement, a redundancy, a relationship breakdown. Financially, based on the situation, their individual characteristics, medical, social or environmental factors by some public services but not others. And these same people at other points in their lives or in other situations might not be classed as vulnerable. Vulnerability should be assessed with three key factors in mind. The personal characteristics, so the physical makeup of that person, an elderly person, person with a terminal illness, person with a mental health issue, a learning difficulty, that's inbuilt into the character, a physical disability, or the personal circumstances, someone who's just lost a job, someone who's just recently bereaved, somebody recently divorced, somebody pregnant. So the characteristics is the physical makeup, the circumstances, things that are affecting that person's environment. And then we need to look at the external factors. What is happening to that customer? Are they being pressed for payment by an enforcement agent, by payday lenders? Are they managing through a bereavement or a financial shock, such as losing the job? So what we're saying is we look at the customers, the characteristics, the physical makeup, look at the circumstances, look what's happening to them, and can they protect themselves? Can they be taken advantage of? Do they know what's happening? And it's only then that we can decide whether or not they're vulnerable. And of course, some people can be temporarily vulnerable. You know, a pregnancy ends, you find a new job, you meet a new partner, and then yes, you are vulnerable for a period of time, and now you're through it. But if you're vulnerable because of your characteristics, your physical makeup, such as a mental health issue, learning disability, you know, terminal illness, that's not going to change. So you're more likely to be vulnerable permanently. We use IDEA with vulnerable individuals to assess a customer's ability to pay, ability to communicate, and third-party help, whether they need third-party help or whether they are currently getting third-party help, because ultimately we are collecting money. Local authorities collecting money, enforcement agencies collecting money, and when we identify vulnerable individuals, we still need to collect from that person. That person does still need to pay. Using IDEA helps us get to that outcome. So what does it stand for? I is impact. What does the condition stop the person doing? What happens to that person? How bad is it? Just because somebody is in a wheelchair does not mean they can't pay. People, disabled people, hold down really good jobs. Doesn't mean to say you can't work because you've got a disability or pregnancy or first language isn't English. What we need to find out is, yes, this is your vulnerability characteristic or circumstance. What's it stop you doing? How bad is it? The next is duration. How long has it been going on? Is it temporary or is it more long term? You know, is it a relationship breakdown? A divorce, a bereavement, pregnancy, so that we can establish the temporary situation of vulnerability, or is it going to be more long term, like a mental health issue or a learning disability? And then episodes. Has it happened before? Could it happen again? And finally, assistance. Is the person getting any help, or does the person need help? And whilst we have a conversation with someone, and that can either be on the telephone or on the doorstep, and we go through IDEA, we're assessing their ability to communicate, their ability to pay, and third-party help. So IDEA is a really good tool for helping to identify vulnerability and how it impacts on them. Aside from system changes, training and vulnerability awareness were the most extensive part of the transition process from the old enforcement regulations to the new. Enhanced training processes for identifying and handling vulnerability were paramount. It resulted in the introduction of specialist teams to support staff and customers, supplemented by enhanced training in handling things like suicidal disclosures. So that's vulnerability in about 5 minutes, and it's a really complex subject. And we'll just move on to body-worn video regulation, where the government is taking decisive action and making body-worn cameras mandatory to ensure debt is collected in a fair and safe manner, with those who fail to do so held to account. Making the use of body-worn cameras mandatory relates to High Court enforcement agents and certificated enforcement agents. Does not relate to county court bailiffs who are employees of HMCTS who are out of scope. The decision that all enforcement agents must record their activities also includes in-house counsel teams. It offers reassurance to the public that standards are consistently high, gives protection to enforcement agents who do a difficult job on behalf of local authorities. And Justice Minister Paul Maynard said, whilst most bailiffs act above board, body-worn cameras will provide greater security for all involved, not least consumers who are often vulnerable. Further details about how these regulations are going to work will be published in the summer, and that statement was July 19, so we're now in the autumn, so we've not had those details, but I'm sure that the election is delaying things like that. So how do we use it? What is it? It provides an audio and video independent record of conduct. Footage can be made available to the creditor to view securely. It assists in training and identification of vulnerability. It demonstrates openness and accountability of the actions. It's proven to improve engagement. Customers, when they realise they're being filmed, want to come across as compliant, want to come across as reasonable people. So it does improve engagement and reduces conflict. And it also reduces complaints and incidents. It evidences ongoing commitment to providing professional, ethical and compliant services to clients and customers. And finally, complaints, which leads in nicely really. The new regulations have minimised complaints massively. And how do enforcement agents work even further to minimise complaints? We provide easy to contact customer support. What we want to do with a customer who's complaining, we want to be able to talk through the issues with that customer and resolve it early before it escalates. Extensive use of body-worn video is massively helpful in resolving complaints, because if there has been an enforcement agent visit, we can look at that video and we can fully understand what the customer's complaining about. We provide regular training for our complaints teams and also our enforcement agents and also our frontline staff in contact centres to make sure that we minimise complaints wherever possible. And where we do have complaints, it's about resolving them successfully. Each enforcement agent company will have an established complaints policy and procedure which will be approved by the clients that we work for. There will be a 3-stage escalation process, including an escalation to local authorities and the local government and social care ombudsman. Dedicated complaint handling teams, specially trained to ensure case ownership dealt with thoroughly and fairly, with an emphasis on resolving early and also keeping the client involved throughout with all the relevant data that you need.
So we've come to the end of our webinar. We'd like to thank you all for joining us. I'd like to thank Dave for his contribution. I hope that you understand a bit more now about the legislation and regulations. And if you've got any queries, please get in contact with us at enforcementagencyservices@ypo.co.uk. Thank you.